Law at Work is sponsored by Perit van Niekerk Woodhouse Macholo, leading labour law specialists representing businesses throughout South and Southern Africa, as well as Case Law, the quick, fast and easy labour law search engine.
Today's employer faces many challenges, with labour laws often perceived as obstacles, hindering growth and profitability. Over the next few months, work law will tackle many contentious and often misunderstood employment issues. There has been a lot of focus on the issue of sexual harassment lately, and as a result, employers are wondering where their responsibilities begin and end. Joining me in the studio to shed light on the subject from Wits University is Professor Mary-Lynn Christensen. Welcome, Mary-Lynn.
Hello, Simon.
Mary-Lynn, it strikes me that in many boardrooms, the subject of sexual harassment is still perceived as a joke and perhaps not taken very seriously. Could you perhaps tell us exactly what sexual harassment is and what the law says about it in the workplace?
Yes, Simon. Sexual harassment can come in many forms, but we look at quid pro quo harassment, where an employer in a position of power would try and get sexual favours from an employee. There's a hostile working environment where the employee might feel threatened, where comments, verbal, physical, attention, etc. is unwanted. It's usually in a male-female situation, but it can be in a same-sex situation as well. And the law has got very definite protections in place now for people who feel that they might be the subject of sexual harassment. Clearly, we always start with our Constitution, and there are rights in the Constitution which protect an employee in this situation. You've got rights such as your right to equality, and we'll discuss that a little bit more later on, your right to human dignity, and the general right to fair labour practices. We could go into other rights which might impact on it as well. There are various statutory provisions, and perhaps the most important statute for this is the Employment Equity Act. And the Employment Equity Act looks at eliminating discrimination in the workplace and protecting employees. And it also looks at the employer's obligation. And again, we'll look at that. As you say, some employers look upon it as a joke, but there are serious obligations placed upon employers. And then there's a code of good practice on the handling of sexual harassment in the workplace, and that also we'll look at as we go through. And of course, the Labour Relations Act protects all employees against unfair dismissal or unfair labour practices.
Okay. Mary-Lynn, the employer obviously has a duty to create a safe working environment in many areas. One could look at a factory where workers have to wear hard hats. When it comes to sexual harassment, is the employer obliged to provide an environment where this cannot occur?
I think the basic principle is, in terms of our common law, all employers have a duty to provide a safe working environment, and clearly an environment free from sexual harassment would fall into that common law provision. But as I said, in the looking at the legislation, the Employment Equity Act also now provides a statutory obligation, and the employer has, if an employee brings to the employer's attention that there's sexual harassment in the workplace, that employer has a definite obligation to actually try and find out what is going on and to ensure that there's an environment free from sexual harassment, so to create that environment. Okay. So that would put liability onto the employer. And then there's the Employment Equity Act, the Code of Good Practice, which has various provisions.
Would the employer only become liable after they become aware of the event?
No. Section 60 would give that liability after they become aware of the event. But prior to that event, the employer now has an obligation to put in place various measures, policies that an employee is aware of, that the employee can follow if there's a problem, but also to create a hostile free environment, a sexually harassment-free environment.
Yes. In terms of the policies that are put in place, having spoken to a number of HR directors, people are talking about these grievance procedures that need to be put in place. But often it would appear that whilst the executives are aware of this policy, it doesn't filter down into the organisation. What are the repercussions for an organisation not sticking to its grievance procedures?
Well, I think there are various ways of looking at this. First of all, there are obligations on employees also to become aware of what the policies are. Policies are often put just as part of a contract, and it might be that employees never read them, but they do have an obligation to be aware of these. But they're also often made public, put on the walls, put in the rooms, etc. So to answer your question, the employees have rights, but they also have obligations to find out what it is. So depending on whether you're the perpetrator or the victim in this situation, it would make a difference.
Speaking of the employees' rights, let's talk about their rights of recourse. Somebody who has been harassed or who is alleged to have been harassed, they've tried to go through the internal process without joy. What happens next? Where does this case go?
So what you're saying is they've been through a grievance procedure and there's been no resolution of that procedure.
The perpetrator is still employed and possibly continues to harass the victim.
Right. The employee can then take that dispute first and foremost to the CCMA for conciliation. And if there's no conciliation possible at the CCMA, it can go forward to the Labour Court. So we do have provisions in place, as we do for all employment policies and all disputes, to go to the CCMA for conciliation, arbitration, and then to the Labour Courts.
Okay, now many awards are obviously capped that the CCMA and Labour Court can make. Does that apply to this environment as well?
Yes, I think what I should have perhaps said just before we talk about, well, we can go on to that later. In terms of the labour legislation, the Employment Equity Act and the Labour Relations Act, its compensation is usually capped at 12 months, or if it's deemed to be an automatically unfair dismissal, then it would be capped at 24 months. Now, the whole question of sexual harassment is whether it is discrimination in terms on the basis or the grounds of sex. And I think it's generally accepted now, and it's been put into the Code of Good Practice, that sexual harassment is a form of discrimination. Section 6.3 in the Employment Equity Act clearly says that, but the Code stresses that it's a form of sex discrimination. And therefore, if you show that there has been sexual harassment on the grounds of sex, and you've dismissed or there's some sanction short of dismissal, then you would be able to claim unfair discrimination, and it would be capped at 24 months. Having said that, what we didn't really talk about before in terms of recourse is in terms of the common law. Would you like me to go into that?
I don't think we're going to have time for that, Marilyn. Yes. We'll probably have to come back to it in another issue.
Yes.
Thank you very much for your time this evening. Join us next week when we look at the different definitions of an employee and how this affects the employer.
Law at Work is sponsored by Perrett van Niekerk Woodhouse Macholo, leading labour law specialists representing businesses throughout South and Southern Africa, as well as Case Law, the quick, fast and easy labour law search in South and Southern Africa, as well as Case Law, the quick, fast and easy labour law search in